Hello, everybody. It's Artie of Artie's Corporate Fiction. How you guys doing? Happy Wednesday. Happy Hump Day. Hope you guys are doing well. I'm doing okay. Family feuding notwithstanding, but I'm not going to get into that. We are going to have a fairly short stream today. We're going to look at two instances. One is a Karen, a very obvious Karen sovereign citizen, that just dropped today, as well as we're going to listen in on Lane Myers' bond hearing. If you don't know who Lane Myers is, he's kind of a crazy person who's had a weird vendetta against somebody at a university law professor, or excuse me, I don't think she's a professor. She's a faculty member at a university school of law. And he runs the gambit, the usual First Amendment auditor playbook of posting videos, live streams, basically saying every horrible thing you could say on live, while also posting her work information, including her work address, work phone, work email, etc., for all of his fans to leave some fun messages for her. So we're going to get through all of those, get through that hearing, see whether or not he gets to get out, because he was arrested right after appearing at a previous hearing for other charges. So he's got multiple charges against him now, mainly because he doesn't know how to shut the hell up and not post on YouTube. That's the long and short of it. So. But first, we're going to start off with a Taco Bell drive-thru, apparently. There's another hearing today? Oh. Well, we might end up listening to that. Who knows? But we're going to start here. And, for those who are unaware, the championship round between Judge Simpson and Judge Oakley will be at 8:00 p.m. Eastern Friday. So look forward to that. I would say you get at least a full hour of voting. I may add more to that, but you're going to get at least a full hour to place your votes in the championship game between Judge Oakley and Judge Simpson. Again, Friday, 8 p.m. Eastern. All right. Let's get this show on the road. What's up, KFAR? I see you.
Citizen was driving without a seatbelt and proper license plate while refusing to identify herself to the officer.
I will break your window, yes. I can break your window and to place you under arrest for failing to identify yourself on a traffic stop. Yes. No, I wish to identify you for driving with no seatbelt on. All right. Let's...
Open your door! Open your door!
I don't need a warrant. No, I don't. She came out of the passenger seat, the one on the phone over there.
Okay. Hey, what's going on? What's going on?
I don't know.
Okay, who is she?
It's a friend of mine.
Okay.
We've been with my mom to play a game, and so she took me home.
Okay.
She does not own me. She's not my king. She's not my ruler. She's not my boss.
I told you I'm pulling you over for failing to wear your seatbelt. Yeah.
That's my determination. Self-determination.
The state law requires you to wear a seatbelt.
I'm not in the state.
Okay. So, are you refusing to identify yourself?
Do you believe I'm in the state?
Are you refusing to identify yourself? You are in the state of Washington, traveling along the highway.
Can you prove it?
You are. We can see you within the state of Washington. Can you prove it? Well, I mean, if she takes a picture of you right now, yeah.
Because the statutory definition of in the state, it's in the laws, it means federal territory.
No, it doesn't.
And this car is not federal territory. My body is not federal territory. My body
Nobody said it was.
doesn't belong to the state.
I'm going to explain to you what's going to happen,
My
okay?
body doesn't belong
If
to
you refuse to identify yourself during a traffic stop, I'm going to break your window and you will be arrested and taken to
Does she have her was she trying to actually have her fingers in her ears like a child? Apparently so. Awesome.
jail. Do you understand?
You know why she's not cooperating? No. What's her name?
I don't know her that well. I just met her.
How long ago did you meet her?
I think she's a work friend, so like 3 weeks, months maybe.
Okay. And you don't know her first name?
No.
It's kind of weird to have a friend and you don't even know her name.
I think it's Robin. I can't really think right now because I'm panicking.
You have a window punch?
I don't. See if Peter does.
You're terrifying her. You're gonna hit me. You're gonna hit
Give
my
a window punch?
You're gonna hit my window.
Yeah, I'm going to break your window.
Private property.
I am.
Why are you gonna do that? What
Right now you're under arrest.
Are you trying to break the window?
What?
Well, we're going to.
Yeah.
What's my name?
I don't need to. That's the problem.
You don't
Right
know-
now you're under arrest.
So,
Do you understand?
Robin.
What?
Do you calm down? Okay.
If she will get away from my car, I will
So-
come down and speak to you. If she will back away and get away from me, tell her to get away from me. And she look at me.
That's up to
Tell
her.
to get away.
That's up to her. If she wants to
Please tell
stand
her
there,
to get away
she's
from me.
welcome
What
to
is your
stand there.
name?
My name is Officer.
What's your first name? Diedrich?
The way they bleeped that felt like they were like Officer.
Dieter.
Dieter?
Yeah.
Okay.
The investigating officer hadn't realized it yet, but she had also arrested the driver's boyfriend for pulling similar antics sometime in the past.
So my understanding is that you are anti-police, anti-government.
You have a misunderstanding.
Okay,
okay.
What is the misunderstanding?
I don't understand what she's doing.
Okay,
I
so
don't understand.
so I think she already explained it several times,
I
but
would
you were
like to know
stopped.
where the warrant is, and I would like to know what evidence the city of... Wait, let me finish. I would like to know what evidence the city of Centralia is using to make some kind of determination that I am owned by the city to bully
Nobody
the
said
boss
you
around.
are.
What evidence is the city using to prove that I am owned by the city, that you employees that
No.
are paid, that
Nobody-
I am required to follow your company policies?
Oh god,
I
she saw.
don't
Oh,
know why she's doing this, but it's my dad's girlfriend. She's out to get my house. I mean, she works, but I don't know where she works because it's out of town.
Where is your evidence that I am bound to your statutes? Where is that evidence? Do you have it with you?
Reminds me of Dean.
Do you have that evidence with you?
Are you driving in a vehicle?
Do you have
That's our evidence right there.
with you that I'm driving? Where is the evidence that I'm a driver? Because there is a definition.
Okay.
you're literally in the driver's seat.
It's illegal. You guys are bound
Hey,
to know.
what's the code to open the door?
You guys are bound to know this stuff. You guys are bound to know the laws, and you're harming me by not knowing them.
Ma'am, you might want to protect your face.
You're harming me.
Tell her she's under
You're
arrest.
gonna take my body
You're
to
under
jail?
arrest. You're under
For
arrest
what?
right now.
What's my charge? What's the
For
charge?
failing to identify yourself on a
What's the
traffic
charge?
stop. I just told you.
What evidence do you have that I am bound to identify to you? I have the right to remain
It's
silent.
written in
I
written
have
in
the
state
right to remain
statutes
silent,
that you need to
including-
identify yourself,
I have
okay?
the right to privacy. You're invading my privacy by forcing me to tell you my name? You're invading my privacy. It's private.
She had ongoing felony warrants from Colorado,
Oh.
so it's obvious why she wouldn't want to identify herself.
Go ahead
Private
and
information.
Felony warrants for what? Oh.
You're gonna take
we're
me
gonna
to
drag her
jail.
out the
You're gonna
passenger
get my
side,
name, put me in
bust the
jail.
passenger side
You're
window
gonna
so we don't
Who are
hurt
you
her
going to
with
charge?
glass.
And who is the complainant?
just
Who
say
is the private man or woman complaining
Oh my
against
God.
me?
So
Who is
At this point, she's just like throwing out lines just to see what sticks.
the private man or woman?
go ahead and bust that
Who is
window.
who is
All
the
right.
plaintiff? Okay, if I go to court, who is the plaintiff?
This
I
the
go
Robin, I'm gonna break the window. I'm going to break the window.
I have a question.
Okay,
If I go to court, who is the plaintiff?
No, my God,
If
we're
I
not
go
here to
court,
talk
please
about that.
answer.
I'm going to break the window.
Please don't break my window.
Okay, then open the door, okay? I'm about to break it.
those are your two options.
Don't touch me.
You're under arrest.
Oh, there you go.
You are under arrest.
Boo! Man, I feel like we got cheated.
Don't hurt me. Don't. Let me put my phone on my. You guys. Don't hurt me. You're hurting me. You're hurting me. You're hurting me.
You got it,
You're
Dieter?
hurting me. God, they're hurting me. You're hurting me. You're hurting me. You're hurting me. Don't tell them anything.
The bottom line is the plates don't match the car either, from my understanding.
Yeah.
Do you know why that is?
No.
Because they're exempt plates is what it says.
No, I know, I get it. I know that she did it. I don't know why she did it. I didn't care to ask, because it's not my business. And because so I haven't been happy with my dad. He's very anti-government, and I'm already stressed about other.
Oh God! Oh, I feel bad for the daughter because the narrator already said the boyfriend was also hooked up for similar sovereign citizen BS. So apparently dad found a girlfriend who's also a sovereign citizen. So the daughter, oh man, that sucks.
The stuff that I don't ask
Oh, your
questions.
dad is?
Yeah.
Okay.
So yeah,
Okay, so he's anti-government.
possibly.
Okay, so you think that's the whole reason of this?
Possibly.
She's just anti.
Yeah.
Okay.
Yeah.
So
Because, like-
what's her first name again?
Sky, S-K-Y.
No, her.
Oh, Robin,
Robin.
I think.
Okay.
Yeah. I'm pretty sure. Yeah.
Okay, thank you.
You're hurting me. You're hurting me. You're hurting me.
Okay.
You're causing me harm. This is not equitable. You guys are nuts.
So Robin, if you
What?
not calm down,
Equitable.
you're gonna be going into a rap. Okay.
Ooh, get the rap.
The rap is a
Fine,
burrito.
just shut up.
Okay. So you need to cooperate
up.
with us.
I don't need to do
Are you gonna tell me who you are, Robin? Last name, date of birth? Spread your feet for me. Spread your feet for me. Alright, she's good to go. Where are you? Move over here so we're not going further. Alright, Robin.
Please keep my phone off the top of the car.
You're gonna be booked into the county jail under Jane Doe. Alright?
Yeah. Who's the charge? Who's charging me?
I am.
Really? What's your
Yep.
name?
Sergeant Finch.
You have to do it as a private man or woman. Private woman. Are you going to be on the other side of the
discuss that
aisle?
with the judge.
No, you're going to be on the other side of the
You
aisle.
got her. I'm gonna check with them.
Are those cuffs too tight or are they good?
They're too tight on my left side.
Really? Imagine that.
Really?
It's not equitable. You all are trespassing upon my rights. I have all of my rights. I have the right to remain silent. I have the right to my privacy.
And please exercise that
I
one.
have the right not to tell you anything.
All right.
I have that right.
Go ahead and step in the car.
You're trespassing on my rights. You're trespassing on my rights. You're trespassing on my rights. And if you guys swore enough to support and defend the Constitution, you are trespassing.
I mean, I don't. The description doesn't say what her warrants out are for Colorado. But if they're extraditable, she's gonna be staying in until she's sent back over there.
You are not an American.
All right.
You are not a patriot.
Would you
You're
like
a
me?
criminal.
Would you like me to read your rights?
You already trespassed upon them, and I have the right to remain silent. So quit asking me your questions and
Fair
go
enough.
away.
Two options. We can write a search warrant to try and find indicia in the car to determine who she is. Do we know anything besides?
It's not unintelligible. It's indicia. INDICIA.
Robin?
No. We can get her dad.
It's a fancy word for like evidence or, documentation. Yeah.
Name.
Her dad?
No. The gals that she was with.
Is her dad D? Oops.
Maybe.
Her last name's
Would that sound right?
Guy. Yeah, he's a constitutionalist as well.
That sounds right.
He's the one who was going the embezzlement charge on, not embezzlement, extortion.
Extortion? Wait, what?
The embezzlement charge on, not embezzlement, extortion charge on me.
Okay,
Yeah.
so let's look at Dean. See if they have involvement.
With Robin off Jace. She should know better then, because I put him in. He got a felony because of me.
The female's car was impounded and seized for investigation against the license plates, but it didn't sit well with the owner.
You don't have a search warrant. You don't have a warrant. You listen. You are men.
Stop talking.
You are
Okay. Okay.
men.
You're going to
and
jail.
You are gonna
Your vehicle is being seized for a search warrant to identify you. Do you understand? If you
You can't identify me with that. I won't. But I wanted to know why you were searching my car without a search off.
The female was charged with no valid operator's license without identification, refusal to give information to or cooperate with officer, resisting arrest, operating a motor vehicle without insurance, failure to renew expired registration over 2 months, and failure to wear safety belt. YouTube thinks you'll love the video on.
Well, I mean, I kind of wish we had more info on what her felony warrants were for Colorado. I also want to know about her husband, or not her husband, her boyfriend, and his apparent extortion charge. I'm actually very curious to see that. So I'm confused. I thought people were saying that Lane Myers is is it live?
Result. There simply is no proof evident here. The state cannot meet its burden to deprive Mr. Myers of his highly important constitutional right to be released pending trial so he can defend himself outside of custody. Finally, there is the content of the alleged videos. In the first one, Lane.
All right. I'm gonna roll back. I want to roll back. And he'll listen to the defense arguments.
003. Today, I think we're ready to proceed. Mr. Parton.
Yes.
Yes, Your Honor.
But that's Hawk. Yes, but that's his attorney, not him himself.
So Mr. Myers is not going to be testifying today?
No, we spoke about it. He's shaking his head. No, he's not going to testify.
Okay. And it's my understanding, Mr. Parvin, that you did have an opportunity to meet with Mr. Myers today in the courthouse prior to the proceeding. Is that correct?
Yes, and we discussed how this is going to proceed today.
Great. Okay. I guess we're ready for argument. Ms. Stiles.
Your Honor, on March 14th, 2025, Mr. Myers was present for his arraignment, which was also his initial appearance, where he did receive release conditions in this case for felony offenses for which he has been charged. After that date, then he went and posted these two videos. These two videos from March 16th and March 17th were both done while he was on release. At the time, he did have the active injunction against harassment, which is an element of the aggravated harassment statute. As the evidence has shown, that injunction was served. It was in favor of the victim. It was served on Mr. Myers while he was in court, and it was still valid as of the date of these offenses. For aggravated harassment, we have to show that the defendant with intent to harass or knowing that he was harassing another person, and then it's that he communicated or caused a communication with another person by verbal, electronic, mechanical, telegraphic, telephonic, or written means in a manner that harassed. And so for that, he caused a communication because he went onto his YouTube channel knowing he has, over 15,000 followers. He went onto that channel and he posted the contact information for the work contact information for our victim, Shannon Walker. And the only reason that he would do that is because he's trying to elicit people to make the contact with her. He could have talked about his case without ever posting her information, but he put it up there clearly for all his followers to see so that they could see in the slapping style sanctions video where he's putting up her work address. And then in the other video, I forgot the name of it, but publicly available public information video. He put that one up and that displayed her email address. It displayed her phone number. And both of those then caused the communication with the other. He knew that this would happen because he was on notice. As you heard from the testimony yesterday, Mr. Myers has acknowledged that he knows his followers reach out to the victim. He knows that this happens. So he's on notice of that. He knew that the nature of the type of the contact they have, and so he's still doing it. So he's still eliciting them to then reach out to the victim. The definition of harassment means conduct directed at a specific person, which would cause a reasonable person to be seriously alarmed, annoyed, harassed, and the conduct, in fact, seriously alarms, annoys, and harasses the person. So we know it's directed at a specific person. This isn't just him talking about his case. He directed it specifically at Shannon Walker by putting up her information. So he's then calling on his followers to reach out to her because this is something he's had the history of doing this, of repeatedly putting up these videos for Shannon Walker and putting up the contact information so then people would reach out to her. And in fact, that is what happened. You heard some of the voicemails. You heard two of the voicemails that were admitted into evidence, and then you admitted into evidence were some of the emails that she was getting that were in response that happened shortly after he posted these two different videos with her contact information. One of them specifically references, it was the gentleman who was coughing throughout, specifically references the content that was contained within that slapping style sanction video. And so it's clear that that communication was in direct response to that video. It references the University of Arizona, which is referencing the injunction that he put up. And while we only played a clip of that, the court does have the full video. And in the full video, he does go through and talks about that there was this thing in the police report that referenced the X, and that he talked in that video about that, and then that voicemail does reference that. So harassment, you have both the objective standard and the subjective standard. So you have the objective standard of what a reasonable person would they be seriously alarmed, annoyed, and harassed by this conduct. And with the emails, the content of these emails is referencing, you know, her being raped, her being shot, things happening in front of her children, these voicemails of going to her home. This is all conduct that would cause a reasonable person to be seriously alarmed, annoyed, and harassed. And then you also heard Detective Brown reference that Shannon Walker is in fact seriously alarmed, annoyed, and harassed because she's afraid for her family, she's afraid for herself, so she has safety concerns. So we have both the objective and that subjective standard. And so these elements have been supported at this hearing under Article 2, Section 22. The standard is proof evident, presumption great. And we have the videos that were produced by Mr. Myers. So we have the evidence showing that he was doing this, the testimony indicating that he knew this is what his followers would do, that this has been going on for a period of time. So this is repeat communications. And then we have the result of what happened when he then caused a communication with another by causing his followers then to reach out to Shannon Walker. So for those reasons, we would ask the court to find that we've met that standard and to hold him without bond.
Thank you, Ms. Stiles. Mr. Parvin.
Thank you, Your Honor.
Your Honor. As
All
there
right,
appears
let's
to be
hear
many
it.
people watching this proceeding on YouTube, I'm going to
Oh, yeah?
explain a little about what this proceeding is not.
Oh boy.
This hearing is not about whether Lane Myers is guilty or innocent of any crime. This hearing is not about the 14 charges already filed with this courthouse. This court. The rules of evidence are more relaxed for this proceeding. This is not a trial on the evidence.
Okay.
This hearing is only
just a
about
bond
2
hearing.
alleged incidents involving YouTube.
Okay.
Both the United States and Arizona constitutions favor pretrial release. People are presumed innocent. People should not be in jail where it is incredibly hard to defend oneself. Arizona acknowledges this fact under the rules of criminal procedure and requires the least onerous conditions release necessary for the situation. Bail is a right in the state that should not be taken lightly. Before this court can deprive Mr. Myers of his right to bail, his constitutional right to bail, it needs to find that there is proof evident, both that Mr. Myers was in fact on pretrial release and that the alleged conduct was a felony. What is proof evident? Proof evident is more than probable cause. In fact, it is more than a preponderance of evidence. Although the courts have ruled the level of proof does not need to be beyond all reasonable doubt, unlike a jury trial, the courts have made it clear this is nonetheless a high standard of proof. It must be clear to this court that a felony was committed on pretrial release. Let's start on whether this even happened on pretrial release. The detective testified he thinks these videos were made after Mr. Myers was on pretrial release. However, detective admitted he had no way of knowing for sure when the videos were made. He didn't know the time. He appears to be going off what he thinks YouTube may have labeled it as, but he doesn't know for sure. The state didn't submit any evidence of timestamps proving when these videos were made. Furthermore, the minute entry
Did they not? I mean, the way you would do it is you would probably screenshot Myers' page, the page where the videos are, and then look and see when this is being when it was streamed.
These were not entered until March 17th. There simply was not time to enter anything on March 14th. The hearing ran late. It was heated. Security was here. Mr. Myers was escorted out to the situation because it was so heated and told to come back the following week to meet with pretrial services. Given this situation, how late it ran, and as the court noted, we ran late yesterday too, it had to be continued, same reasoning. I argue that the proceeding was not official until the 17th, when the minute entry was filed with the courts, and Mr. Myers officially knew his release conditions based on that minute entry, given how heated it was and had he escorted out. However, the biggest argument here is that the conduct stopped. I asked the detective if there were any further videos reported. He said no, or not that he was aware, but it was a no. This means that once Mr. Myers was given his release conditions and on pretrial release, he was aware of them and stopped all conduct of these videos. Mr. Myers was not arrested on these new charges until March 20th, in court, by the way. He's doing his duty to come to court. He's always coming to court, never fails to appear. There were no videos posted on March 18th. There was nothing posted on March 19th. The conduct stopped, pursuant to the detective's own testimony. Mr. Myers was summoned to go to court. He knew these charges were coming. He was understandably upset and exercised his First Amendment right to make some YouTube videos expressing his concerns. He was not on pretrial release when he received the summons. The fact that these videos stopped before he was arrested for these charges a few days later, that has to mean something to this court. this shows that the court's order of pretrial release was obeyed once it was official. This court should not deny Mr. Myers' right, his constitutional right to bail, on a timing of incidents so close together when the testimony shows the video stopped. I am not arguing the state can't charge Mr. Myers for what they believe were contained in these new videos. I am arguing that there is no proof evident these incidents occurred on pretrial release. The conduct stopped. This court should not deprive Mr. Myers from his right to bail when the evidence shows he complied and stopped making videos. Next, I want to discuss whether a felony even occurred. The state argues that 2 clips presented to this court rise to the level of aggravated harassment. However, if the court reviews the state's own exhibits that they submitted to you, the email started March 15th. If the detective believes, but again, he's not sure when exactly, but if he believes that the videos happened later, then why did the emails in response to these videos start on March 15th? Either the videos occurred earlier in time, which means Mr. Myers was not yet on pretrial release, or Ms. Walker's email was already known to the public, in which case Mr. Myers was not responsible for this, what happened after. Or maybe it's both. But no matter which route the court prefers, it's the same result. There simply is no proof evident here. The state cannot meet its burden to deprive Mr. Myers of his highly important constitutional rights to be released pending trial so he can defend himself outside of custody. Finally, there is the content of the alleged videos.
Oh boy.
In the first one, Lane Myers is simply defending himself and explaining a court document. Is the state really arguing that the explanation and posting of a court document listing the University of Arizona Law School's address somehow caused people to mail? Nowhere in
yes, when you're not just posting the Arizona's address, he also was showing Walker's email and her I can make an assumption that it's her room number and her phone number.
In that video, did Mr. Myers tell anyone to contact Ms. Walker? He simply was explaining his legal proceeding and how he feels about it. That's not a crime. Certainly wasn't a felony. Maybe the court made a mistake in not listing.
This is exactly like what other auditors do. They're like, do not call 856-781-2493. Yeah.
The law school's address is confidential. Maybe it should have been. I don't know why the court, left that non-confidential on this injunction. However, if there was no mistake here, then certainly there's no crime in posting the address of a law school. The court should see this was a legal discussion in this video and had nothing to do with contacting Ms. Walker. In fact, the first thing the state mentioned was it requires intent. Clearly, there's no intent in that video to harass anyone. It's just explaining an injunction order, how he feels about it, and how he's defending himself. The second video is admittedly slightly trickier. However, as the court saw, this video was silent. It was labeled public information. Ms. Walker's information was not the only one listed or displayed. The video went through several pages of the University of Arizona's website and showed numerous people and their credentials. If the court reveals the entire video, although we only saw a clip, even more names are listed. Public information. Now, it perhaps would have been more prudent not to post anything at all once the summons was received. With that being said, Mr. Myers has a First Amendment right to talk about his case or explain how easy it is to see public information online. If the video were solely focused just on Ms. Walker's contact information with instructions to contact her, that would be one thing. But it was a constantly changing video, as the court saw, flashing various things real quick, showing many people. That's not a felony. Now, lots of people were upset.
Motherfucker. Sorry. Dude, I'm pretty sure the prosecutor's going to say that we're not supposed to be looking at this in a vacuum.
When Mr. Myers was charged, lots of people watched the live streams as he was arraigned. As has already been established, lots of people must have already had her email. Or if they didn't, these videos were posted earlier and he wasn't on pretrial release. It's one of the two. Lots of people were upset. What we heard yesterday about what others, not Mr. Myers, third parties, I don't know from where, what these third parties, these people are doing, watching these videos, he's commenting, what these emails, it's disgusting. It's despicable. I think it made us all cringe, myself included. That is just one of the most awful things I've heard said to someone. It's sad. No one should be doing this to people.
But he's
However,
not going to.
It was very clearly established, including by the detective's testimony, that Mr. Myers was not initiating these emails or phone calls. Mr. Myers has never posted anything private about Ms. Walker. He would never initiate a contact like that. This isn't coming from him. These people have her email already. How they got it, I don't know. But it wasn't from these 2 videos. Now, I don't know if whatever Mr. Myers did and those already 14 charge offenses caused these horrible things that's now happening to Ms. Walker. They might have. Sadly, yes. I don't know for sure. Mr. Myers in the process of defending himself in all 14 charges. But whatever he did there, maybe that's what caused that. But that's in the past. That's not why we're here today. The only question today was, did these 2 new videos really rise to additional felonies? They really even committed while on pretrial release? They weren't, Your Honor. These 2 videos didn't add anything. At best, perhaps Mr. Myers may have violated the injunction and might be guilty, based on that video, of the misdemeanor crime of interference.
Well, there's a concession, but he doesn't. But he doesn't care. His goal is to keep him out of jail.
Judicial proceedings, but that is not a felony. It does not deprive Mr. Myers of his constitutional right to release, even if he is guilty potentially of the misdemeanor crime of violating that injunction order. With that being said, for all the reasons already mentioned, I ask that this court grant Mr. Myers release conditions here, because the state simply cannot meet their burden here to deprive Mr. Myers of such an important constitutional right to be outside of custody and defend himself. I'm not arguing the state can't pursue charges. They clearly have. They have some strong evidence for those 14 charges. They do. But Mr. Myers also has a right to bail. The state simply cannot take that away based on this evidence today, simply for these 2 extra videos that did not rise to additional felonies. Mr. Myers should be able to defend himself for those 14 charges, and if necessary, these last 2, which questionably may be additional charges, but not. I really don't think there's enough proof of felonies here, Your Honor. And with that, I ask that you issue some perhaps quite stringent release conditions to ensure this, that everybody's protected here, the victim, but definitely issue release conditions. I think Mr. Myers deserves that. He's entitled to it. The state has not met their burden, Your Honor.
Thank you, Mr. Parvin. Ms. Stiles, last word.
Your Honor, the only thing Ms. Walker did in this case is she happens to be married to a prosecutor. She had no connection, as you heard in the testimony, to Mr. Myers, absent her relationship with her husband, that brought on that Mr. Myers then started this retaliatory smear campaign against Shannon Walker. He turned these people onto her. And so you heard testimony about the backstory, that this had been going on, that he had started posting on her and then causing his followers to be reaching out to her. He then, even though there was an injunction put in place, and the injunction tells him, do not have contact, do not cause contact, do not post her work address, he was put on notice of all of this. He is put on notice that this was happening to her, and yet he continued doing it. He didn't stop, he just kept going. And so then you hear that he's put on release, like he's at the hearing. So this argument that maybe he didn't know because it was a heated hearing, he was at the hearing in person on March 14th. He was present. That's when the court ordered the release conditions. That's when he was notified. He is on release. He had his
okay. So that's why the defense attorney's trying to pull a fast one. She's saying no. He knew what the release conditions were on the 14th, and these videos that they're referencing have been on the 17th.
His arraignment. He was informed of these felony charges, so he knew he was facing all these aggravated harassment charges, misdemeanor charges, the felony charges of aggravated harassment, a stalking charge. So he was on notice of all of these things. And as defense counsel noted, there were a lot of people that were very heated and upset about this. But what did he do? He went online again on the 16th and 17th, and he posted her information again, even though he had been on notice that this was causing all this harm to her, that it was causing these people that were following him to do this. And so he went into it. We don't have to show that that was his intent. The other standard is that he knew that he was harassing another person by causing a communication with her. So he is providing the means for those people to contact her by giving the address and the phone number and the email. So maybe some of them had it, but he was definitely making sure more people had it, because there would be no reason for him.
So the difficulty when it comes to these cases with auditors and the whole call flooding is that it's hard to try and make that actual causal connection between what people did and the auditor. Because the standard defense is like, hey, I didn't explicitly say anything. I didn't tell people to do this. They did this on their own, and all I did was post what is obvious public information that anybody could go look up on themselves. How can you prove that it was my video that caused them to look up her information and therefore make the call?
To be posting that information to those people other than calling on them to then contact her and take that anger that they had and direct it again towards her. Again, because he's retaliating for the fact that he is now facing these charges. You heard the detective testify that he himself, when he went on YouTube to get these videos, that he himself was able to see when these videos were posted. And then the court got the voicemails that then came right after it, showing that this was in response to what he was posting. So he was calling upon these people to do that. And this isn't where we just have to say in this vacuum of just these two charges. The history matters into what his showing.
Yes, thank you. I'm glad you brought that up. We're not looking at this as though it's in a vacuum. This has been a pattern of behavior. Thank you.
Intent or his knowledge of this. And so that's why you heard the detective testify about that history, that he knew what the response was going to be. He did it anyhow. And so it meets that standard of that he meets both the objective and the subjective standard of causing that harassment to Shannon Walker. He caused that communication, knowing he had an injunction, knowing she didn't want to have contact with him, and knowing what his followers were going to do. And he did it anyhow, even with all that knowledge. And sure enough, it did exactly what he was setting out to do. She got that contact. She got those harassing emails. She got the harassing voice messages that scared her for the safety of her and her family, all because she just happens to be married to a prosecutor and had no other connection to this man. And so for those reasons, we're asking that you find the standard that the elements of showing that he was on felony release have been met, and the fact that the elements for the aggravated harassment, which is a felony, we have two different dates. The court only needs to find one, but that aggravated harassment was met, and we're asking you to hold them without bond.
Thank you. All right, folks, I'm going to jump off the bench, take a few minutes so that I have an opportunity to review the documents that were provided. I do intend to rewatch the state's exhibits with respect to the two videos. So give me about 10 minutes. I just want to make sure I'm very clear on what we saw yesterday before I issue my ruling. So stay seated. No one needs to get up. I will be back. Give me, I would say, about 10 minutes, and I will rule from the bench.
So again, this is not the court's channel. This is the channel. This is a public service. That's what this guy is.
Loyalty oath from the University of Arizona. All of the employees sign this oath.
Okay. Allegiance
to the solemnly swear, support the Constitution, and then right here F. This is. We're looking at the. Hold on. We've got the definition basically, and let's go to the anti-slap. Oh, that's interesting. That really looks like some similar language.
Oh my god. I mean, hopefully if we're lucky, we don't have to wait very long. Now we're
He did not testify.
Now we're caught up. We're live. I'm refreshing the page. So, Tones, could one argue that he shouldn't be posting that information at all, as he stands to gain from them being in a position to be harassed by people he expresses his contempt to? The problem is that that's very vague. It's a vague thing because, again, we're talking about, again, this is why it's difficult, because the state has to prove is specific intent, that he intended for his followers to go after her. And because you're allowed to criticize your public officials, I mean that's obvious. And public officials, their public information is available online, as they should be. I'm not even disputing anything about that. It's just where do you go from? What's the breaking point between I'm voicing my opinion about this public official and you know, and I think you should too. And I want to make this person's life a living hell because they did me wrong. It's not easy. But the problem is with these kind of characters, these guys think that, you know, public. They think everybody who works in state government is a. I would say it's the call of the perceived call to action. It's because I mean yes, but again they're using they're very I don't want to say smart, but they're very careful with their language. They try their best to not be explicit. They try to couch it in language that would, without any other context, would be benign. But again, we're looking at a totality. We're looking at a pattern of behavior. We've listened to this Lane Myers guy. He is absolutely, completely disrespectful to anybody who gets a paycheck from a public body. Jesus. You okay, buddy? I'm trying to think. And I'll give you an example. I mean, I'll give you an example of this. Like, I think we've all seen, especially during election years, we've all seen those political ads where they're telling the viewer, you know, call Senator Cruz and tell him do not take away my Medicare or some other bullshit, or call Representative Crenshaw or something like that, and tell him to fight for your rights, or to not trample on your rights, whatever. Is that a call to harassment, or is that a call to action? A call to action that is, you know, constitutionally protected? It's hard because there's no doubt in my mind that people who act on those kinds of ads, they're probably psychopaths. They probably leave like unhinged shit on voicemails. But you couldn't necessarily blame the ad about that. They're not putting in the contact information. Well, Super J, a lot of them do. Well, do they put the contact information? That's a good question. I have to go look up one of those ads. I know I saw a billion of them. I think it's the official. I think it's the official contact number for the representative. Right. That's a different number. Okay, I could be wrong there. Well, I mean, also, yes, the courthouse, obviously, it will probably be getting the numbers right now. Right? This dude has a judge's phone number right in the description of his channel, of his live stream. He also has blank prosecutors, which is the prosecutor on these cases. They have their work emails and their phone numbers. They have humiliated cuck, which is the husband, Matt Walker, the prosecutor. They have his information on there. And they have somebody else's information on there too. who works for Pima County. I think the way you do the way that the state could show this is by what Hawk you mentioned. If the state can show not just that he's posting information, but that he's doing the call to action. I think if the state could give a totality of the circumstances, I think they could convince a jury that he's harassing these people and sicking them on them. I think what the defense is going to try and do is say that that Lane Myers isn't the one doing anything. He's not the one calling. He's not the one sending emails. He's going to argue that because he's not directly contacting her, I can't be found guilty of harassment. That's usually the argument that auditors make whenever they get hooked up on things like this. And not gonna lie, and they won in a few instances, as far as I recall. Well, I think the post. I don't know. I don't think the posting in and of itself is enough. I think the state has to show more. Because if posting the info was enough, then this guy who owns this channel could get hooked up, and I don't think that would be the case. It would have. It's the only way the state could prove this is by giving a totality, giving the whole thing, all the videos, all the statements within the videos, and all the actions that he's doing and what he's saying for his audience to do, all put together. No, I know this guy. Lane Myers is he's completely unhinged. He is absolutely unhinged. Again, we listened to his. I don't have issues with auditors. I have issues with going after people who have nothing to do with the basic issue. I agree too. I have no inherent issue with cop watchers or auditors per se. I don't. I think it's actually perfectly fine to videotape police officers in the course of their duties to say, hey, we're watching. But that being said, that's not what most of these guys do. We all know that. Most of these guys, they act in a way to try and goad and poke and prod at the officers to try and get hooked up so they can get money out of it. Or they're not even auditing police officers. They're auditing private people in order to get them in trouble. We all know that. Or Sally and Hawk both mentioned, or they're going to they go to freaking Ethel at the township clerk's office and shoves a camera in her face and says all the things that they want to say to her, like she's not a person. Like, yeah. Oh, let's see. The video on Lane's court appearance. You mean the one right before this one? I did listen to that. We're all waiting for the judge to get back. What are you DMing me about? I don't think so, Draco. Fair, Tones, my problem with cop watchers is that they act like a solution. Looking for a problem, legit instances of police misconduct are typically recorded by people who weren't seeking it. I mean, maybe, sure. But, I mean, that's not really an argument, like, that they shouldn't be allowed to do what they're doing. I mean, you could argue that maybe that what they're doing is, like, not really productive or not, or anything, but, they're free to do it. It's just the issue is they, most of the time, they're not there to actually, you know, hold people to account. They're there to just, poke and prod and, gain some viewers. Like, if I would respect most of these guys more if they actually, you know, push through on what they do, like asking, you know, going through those public records requests, like they always pretend to do when they go to a township city hall, posting, you know, salaries, if they're able to get instances of misconduct, talking about them. Some of them do, not really, not a whole lot. Most of the time they don't. I would also, yeah, I would agree with you, Hitchbot. If they actually were doing what they're supposed to be doing, these guys probably would have been able to catch Henyard right at the same time as the local police, and not like having Long Island Audit stop by for a day, record a public hearing, and then pretend he did something. I mean, I don't want to, man, this is boring. I hope that she comes back. It's been well over 10 minutes. Sounds like audit them, probably. Well, I know, Tones, but most of these guys, they're inherently anti-government. Like, period. They always have an issue with authority of all kinds. I mean, I'm not going to go any further because I don't want to like start like armchair psychologist talking about them, but most of these guys do seem like they have a chip on their shoulder, and they have this idea that they're free to be the worst kind of human being to police or other public workers, and then fully expect them to just you know, like sit and take it like politely. Like police are required to take it, as in like they're not supposed to like, you know, throw words back or like arrest them for saying mean words. But that at the same time, a town clerk could say, you know, if you're gonna, you know, call me a bitch to my face, I'm not gonna serve you. I don't have to serve you if you're going to treat me like that, you know. And there's like, nope, you have to take it. You're a public servant, slave, etc., etc. I have noticed that Linux, most of these auditors have started shifting away from like law enforcement and like public officials, and are like just going straight up after businesses. It's just now you're fully giving it away. You're not even giving the pretense of doing this under some altruistic goal of government accountability. You're just here as to harass people, for lack of a better term, and get a rise out of them and hope that they do something foolish that you can get money out of. Yeah, and oftentimes I have no 90s. I have no issues with just silently recording from a reasonable distance. My concern is when they provoke and harass the general public just to conjure up content for the channel. True. Yeah, I know. I just described like Dougherty and fucking what's his face, who's facing like 10 years in a Korean prison. And TikTok and half of TikTok. The problem that you sometimes Johnny Somali, thank you. The problem that you see with a lot of these guys is every once in a while they will find out. They'll fuck around, and then they find out when somebody who's like, you know what, I don't give a flying fuck. I'll take a assault charge. I'll take an A and B, and I'm gonna teach you some respect. And then they look like a bunch of bitches when they get their asses handed to them. But apparently, I'm looking at the chat, and apparently there's some drama going on between the First Amendment auditor community. I mean, I'm not shocked. There's drama in every niche community on YouTube, no matter how small or obscure it is. There's always drama. But I'm not shocked that it's there for auditors too. I I don't care. So that's why I don't bother on it. I don't bother to know. I don't care what Direct D is doing or, you know, audit them or Yoakin transparency, Long Island audits, blah, 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 blah. Speaking of just getting their asses handed to, did I see the county jail warden kicking LA out of his building? I don't think I have. Wait, what? Navy girl says Lane Myers threatened Direct D and his family? Why? Well, no, don't answer that. Don't even bother answering that. Lane Myers is he's more than just an otter. He's mentally unstable. So I'm not surprised that he would go after anybody. But he was right about one thing: communities are gay, especially the law tube. I mean, communities are going to be communities. I mean, I still have plenty of respect for my fellow law tubers. I still have a lot of respect for Mike and oh my god, I'm forgetting her name. I'm an idiot. Oh my god. Oh my god, she's gonna kill me. I forgot her. Natalie, thank you. God, thank God. Natalie. Yes, I have a lot of respect for Natalie too. But I also agree with the thing, like communities can get high schoolish. Yes, they do. I mean, that's largely why I maintain a no drama policy in my Discord. I don't care who it is. I don't care if I don't like them. Personally, I don't care if they actually genuinely deserve the mockery. I don't want any of that in my Discord. Because it can easily boil over and turn the server into a complete shit show. Man, what is she actually watching the entirety of Lane's videos? Oh my goodness. Saran is over here. I'm gonna leave her alone. She doesn't deserve it. Every community has drama. I've watched people come to blows arguing over whether or not Goku could beat Superman. I mean, also true. But also, I mean, the answer is Goku, obviously. But yes, you're also true. True. How's my brother doing? He's doing good. It's hard to collab with him because, you know, he's got the whole, you know, baby thing. She's doing fine. She's adorable as all hell. Yeah, they're all good down there. One Punch Man versus Superman. Oh boy. Well, I already saw that video, that like multi-part series about One Punch Man versus Goku, which, man, that was fun. That was fun to watch. That entire series was animated by one person. That's psychotic. But that was a fun watch. I mean, Elspeth, I feel like a lot of people can beat Homelander. He's kind of a bitch. Pre-Crisis Superman or Nick Cage Superman? See, look at chat now. Look at what's going on in chat. This is exactly why I don't put the drama on. I don't talk about drama. The Nerevarine would take the Dragonborn? Fight me? Bullshit. I never even played Morrowind, and the Dragonborn Uber Alles. Look at why is the chat debating superpowered fictional characters? The question is, why haven't we at this point? But no, I was just talking about like drama, how drama can spring up in just about every conceivable niche community on YouTube. And as somebody put in an example of the whole Goku versus Superman turning people against each other, and here we are. We're gonna show the video of LIA getting thrown out of jail. Does anybody have a link to that? Well, oh, I missed you. 1 second. Who would win in a fist fight, Judge Milton or Judge Simpson? I don't know. What state was the first video? God, that was Washington State. They said it. They said it in the video. Checking my DMs. Ah, here we go. All right, I'm gonna keep this page open just in case it comes back.
Always to peacefully exercise our First Amendment right.
Oh Jesus! I hate. I'm already triggered. All right. I haven't closed the other screen, so if Judge comes back, we'll go right back to it.
Right to film in public and publicly accessible areas, to promote transparency and accountability within our government, and to ensure that our public servants recognize our rights and treat us with respect. Let's get record them. I'm sorry, ma'am.
You can't have that in here.
Just don't put your hand on the camera.
I'm not. You can't have a phone in here. The sign says it at the front door.
Oh, okay, guys.
Phone in here. This is publicly accessible area.
You cannot have a cell phone in here.
Who are you, ma'am?
I am the visitation lady, but I do know what the rights are and what the rules and regulations are. The sign is on the door. It also says that you cannot bring a phone.
Issue.
Wait. Oh, she's right. It says it right there. Cell phones and electronic devices prohibited.
Okay, I'm okay. I'm just taking some pictures.
You can't take pictures.
Hey, how are you?
You cannot. Shut the phone off. Step out of the building.
Who are you?
I am Sergeant Horner. I am overseeing programs. And who are you?
Oh, who are you, ma'am?
She's administrative assistant. Can we help you?
Yeah, no, I don't need any help. I don't know why you came over here. I don't need any help with anything.
But you can't be in the building with your phone. That's my at all.
Oh yeah, I could be here. It's a publicly accessible area.
With the phone. You have to secure the phone.
Again, this is a camera. It's not a, this is my phone.
Okay. Well, you need to step out.
It said cell phones or other electronic devices. Doesn't matter if it's not a camera, moron.
It doesn't say no cameras.
Electronic device!
Any electronic devices. That's an electronic device. You need to leave. Yes.
No, it just says cell phones. This is a camera.
Well, I'm going to give you another warning to leave, or I'm going to get assistance.
Go get assistance. Do that. Hey, who are you?
I'm the warden.
You're the warden. Your name?
Don Satterfield.
Don Satterfield?
Yes.
I am recording you,
You're
yeah.
in violation of the law.
No, I'm not.
Yes, you are, sir. You're in a detention center. You can't have a phone in a detention center.
Okay, I'm not in violation of the law. I'm engaging in a constitutionally protected activity.
Out.
Sir, you're not intimidating me.
I am telling you to leave now.
You're not intimidating me.
Put the phone away.
Get your hand off of me.
Out now.
Do not touch me.
I can touch you.
You have no authority to touch me.
You're in a state building.
Federal or state?
No authority.
Call them out. Let's go. I can help you to stay if you'd like. Because
you're not going to touch me, sir.
Whatever you want to do.
You're not going to touch me. Hey, can I speak to a supervisor?
I am the
supervisor.
I'm the warden of this.
It's the damn warden!
Then you're an ignorant supervisor.
He's like the highest one up. What the hell?
I beg your pardon?
Then you're an ignorant supervisor.
Leave the building or I will have you arrested.
I'm here conducting constitutionally protected activity.
Sure.
I'm away.
Out.
Say it. If you're a man,
You're
say
in
it.
violation of the law.
Can I speak to a supervisor that's law enforcement?
I'm as high as I go in the building. I'm asking you to leave.
Can I speak to a supervisor, please?
I'm going to escort you out. Do you understand?
Excuse me?
I'm going to escort you out. Do you understand?
Well, I'd like a law enforcement officer to be here.
You don't get it, do you?
I would like a law enforcement officer to be here.
I am the warden of the facility.
Right.
I have authority to do whatever I need to do in this facility.
Hey, how are you? No need to run in.
Out.
So why we're 1, 2, 3, 4, 5, 6, 7.
I'm going to put my hands on you.
You're not going to put your hands on me. You're not going to put your hands on me.
Then you're going to stay.
You put your hands on me again, you might be staying here.
I beg your pardon?
You might be staying here. You put your hands on me again.
Out.
You put your hands on me again, you might be right next to the guy right there.
You're still in violation of the law. Out.
No, I'm not in violation. What law is it? What law is it?
The Maryland law,
what law is
you
it?
cannot have a cell phone beyond that door.
No, that's not what Maryland law says.
You want to bet?
What's the law?
Out.
What's the law?
Out.
What's the law? Let's look it up. Come on, man. Let's look it up.
Outside, you can look it up.
Don't put your hands on me, man. Don't put your hands on me. This way.
Out.
I'm engaging in a constitutionally protected activity.
Out of my building. Now.
You don't
out
own
of the building
Do
now.
not touch me,
I
sir.
said get out of the building.
Don't touch me. What are you doing?
Damn!
What are you doing?
Violation of law, get out of the building.
What are you doing? Get your hands off of me. What's wrong with you? You're a psycho. What is wrong with you? Is this how you treat inmates in here?
No,
that's why.
better than that.
Yeah.
They don't.
No, they don't. Yeah. Oh, yeah. They don't, right? Ridiculous. No, I'm good right here. Warden.
Warden.
You're a thug. That's what you are. You belong in the cells. Here. You're a thug. A lawless thug. That's what you are. And a coward. You wouldn't do this with all these officers here. You wouldn't. No, he wouldn't, because he's a coward. Wow, ladies and gentlemen.
I'm pretty sure the other officers was trying to hold the warden back, but I mean, that's just what my observation.
That is absolutely insane. So this inmate was just telling me here that they treat them horribly. It's absolutely insane. We have a First Amendment right. I don't know what law he's talking about. Maryland state law. Let me see. You can't bring a cell phone in. Again, this is a camera. It has no cell connectivity. This is a camera. It's used
It's
as
an electronic device.
It's not a cell phone. It's ridiculous.
Electronic device.
He just assaulted me. I got assaulted by the warden of the correctional facility. Absolutely insane. Him and his 12 goons he had with him. Let's go file a complaint on him. I believe there's a sheriff's department over here. Yeah, I would like to speak to a supervisor regarding a complaint,
Supervisor.
please. Okay, what's in reference to? In reference to a complaint?
Okay, give me 1 second. Just have a seat. I'll have somebody else here.
All right, I appreciate it.
Hey, how you doing?
Hey, how are you, sir?
All right. I got help.
Are you a sergeant?
No, I'm a corporal.
Corporal? I was looking to speak to a supervisor regarding filing a complaint.
I am a supervisor.
Okay. I'm sorry, I don't know the command structure here. I apologize. I would
Moron.
like to file a complaint. I saw that you were over there, so you witnessed what happened. The warden of the detention facility, he put his hands on me multiple times, pushed me multiple times, referencing some sort of law that prohibits a camera or a cell phone that's inside of a public lobby. Okay. That law doesn't exist. I've looked into the law. It doesn't exist. I don't know what law he's referring to that makes it illegal to have a camera or a cell phone inside of a public lobby like I am right now. I didn't go into any restricted areas or anything, and he put his hands on me multiple times, violently pushing me out the door. I don't appreciate it. I was engaging in a constitutionally protected activity. I'm filming law enforcement in the course of their duty. I'm an independent journalist. My name is Sean, and I was just filming law enforcement in the course of their duty. I wasn't causing a disturbance or anything. So I would like to file a formal complaint against him. He assaulted me. That's what he did. He assaulted me. Second-degree assault by Maryland statute.
You want to follow
official? I want to make sure that everyone knows what's
We're back.
Going on for the last, I think, closer to 40 minutes now. When the court got back in chambers, I wasn't able to view the actual CDs without a laptop, and one was not available for the court. So I did ask Ms. Stiles and Mr. Parvin to come back to chambers along with the iPad that the state used so that the court could view the redacted portions or the portions that were played in court. Once back there, counsel did ask the court to review states 12 and 14, which the court did. So I had a chance to view most of all of those videos. I will say that for states 12, that was the one from March 16th of 2025, slapping style sanctions. That one we did skip through. It was almost an hour long. And the portions that the court viewed with counsel in chambers were the portions that contained documents. There were several portions where Mr. Myers actually was depicted, I think, wearing a t-shirt and a hat, but the court did not view any portions of the video that had just Mr. Myers on it. So unless there was a document displayed on the screen, the parties did fast forward through that. So I want to make it very clear what this court has had the opportunity to review with respect to this case. So I did review states 12 in its entirety. And that one was about 16 minutes in length.
I think you said states 12. Is that? I think that's.
It should be states 12. I had the full clip says states 12 and states 14.
I just want to be clear, it's the publicly available public information is the one that you viewed in its entirety.
Yes, sorry, and that is, you're right,
So that was-
Exhibit 14.
Yes.
Yep, Exhibit 14 is the one from March 17th of 2025, publicly available public information. That is the one that was 16 minutes. That's the one that the court viewed in its entirety. There were no conversations between the council and court that had anything to do with this case other than literally looking at the videos and reviewing the information and the content that the court wanted to view before making its ruling on this case. Ms. Stiles, anything you want to add to the record that the court made?
No, Your Honor.
Mr. Parvin?
No, Your Honor.
All right. So the purpose of this hearing, and I think Mr. Parvin said it, this is not about whether or not Mr. Myers is guilty or not guilty of the charges that the state may be going forward with respect to this case. What the court is being asked to decide is whether or not Mr. Myers should be held without bond at this time. Arizona Criminal Rule 7.2 is very clear that defendants charged with an offense not eligible for bail under 7.2b1, someone is not eligible for bail based on a commission of a specified felony or any felony while on pretrial release. A defendant must not be released if the court finds that proof evident, presumption great that the defendant committed under B, any felony offense while the defendant was on pretrial release for a separate felony charge. That's what the court is having to decide today. In reviewing the evidence presented in this case, the evidence presented in Exhibits 6 through 10 do establish that Mr. Myers was on release on another felony matter when the offenses in this case were committed. What that leaves is whether or not there is proof evident, presumption great that the charges the state is going forward with today have been established. In reviewing the two videos, the first one, Exhibit 12, that's the one that occurred on March 16th of 2025, entitled Slapping Style Sanctions. The court will note that in reviewing that information, there was a portion of that video where Mr. Myers specifically talks about his X or an X and emphasizing the fact that there was an X. And as the state's evidence established during Detective Brown's testimony, there is a police report also shown in this particular video that makes reference to Mr. Myers as being an X. I don't think that that's actually the case. That was the evidence, but that's the information that was displayed during this
That's the link between
video on March 16th of 2025.
Call and the video.
That information is important to the court because not only does a caller later in that video actually call in and mention the fact that this appears to be retaliation for an X or an X retaliating for information. I think that specifically ties back to the fact that the viewers are responding to the information that was posted on March 16th of 2025 in the subsequent emails and phone calls that are made to Ms. Walker in this case. So I do think that the context of the information that is being displayed certainly ties back to the information that was presented with respect to this video. In that video, I will say there was a brief section that I did not review at all, from I think 117 in the video to 137 was something we skipped through in its entirety. So I don't know even the content that was on that particular portion of the video. So I want to make sure that I have that in there as well so it's clear what the court reviewed. In reviewing the information for the March 17th, 2025 publicly available public information that was 16 minutes, I will note that while there were a number of people that were displayed during that particular video, the initial portion of the video did display Ms. Walker's phone and email as well as a photograph of her on the University of Arizona website.
Yep.
As the scrolling goes down through many of the pictures of other people at the U of A Law School, there is a significant pause when Miss Walker's photograph and information comes up before he continues to scroll down through other people that were employed by the law school. There are many times during this 16 minutes where he stops and focuses specifically on Samantha Walker, her achievements,
Your
the
Honor,
fact
Shannon
Again, it's demonstrating intent.
Shannon Walker, I'm sorry. The fact that she was a key contact at the law school. I will note that there was a portion where there was a focus on, very briefly, Samantha Walker, which is a different person that was also stopped on again very briefly, but it was very clear during this 16 minutes that he continued to focus on Shannon Walker. There was, in fact, a portion as he was scrolling through where there was a photo of Miss Walker with her husband and her children, where she is shown as a member of the board of directors, and again, very much focused on her throughout that 16 minutes from the March 17th, 2025 video. Mr. Myers has the YouTube channel where a number of people follow. Based on the entire context of the communication in this case and the information provided to the court, I do find proof evident and presumption great that Mr. Myers did commit these offenses. That's only for the purposes of, obviously, this hearing as it pertains to the aggravated harassment involving Miss Walker on these two videos, so those two counts. And again, looking at ARS 13-2921, harassment, as the state pointed out, a person commits harassment if the person knowingly commits any one of the following acts in a manner that harasses. Under A1, contacts, or this is the part, causes a communication with another person by verbal, electronic, and other means. It is the electronic means in this particular situation. And under E, it defines what harass means: conduct that is directed at a specific person that would cause a reasonable person to be seriously alarmed, annoyed, humiliated, or mentally distressed, and the conduct, in fact, seriously alarms, annoys, humiliates, or mentally distresses the person. There is no doubt, and I think even defense conceded, that the contacts with Ms. Walker in this case are truly offensive and would certainly cause a reasonable person to be annoyed, alarmed, and distressed, mentally distressed. The aggravated harassment statute under 1329-2101 requires that a person commits aggravated harassment as provided in the underlying statute that I just related, and at the time of the offense, any of the following applies. Under A1B, an injunction against harassment pursuant to 12-1809 was issued in this case and was enforceable. For those reasons, the court does find that Mr. Myers is going to be held without bond today.
Oh no!
Anything else that we need to do on this matter from the state's perspective?
No. He's not getting out.
Mr. Parvin?
I was just saying, if the court's finding proof evident, can we go straight to arraignment so we can start the 150-day timing? I'm wondering if instead of waiting 10 more days, I understand there's an indictment coming already. I'm saying if the court's found proof evident, that's more than probable cause they're getting. If he just wants to have a speedy trial rights and start the 150 as soon as possible.
Ms. Stiles?
Your Honor, the charges are still set to go to the grand jury, so that process hasn't happened yet, so we don't have the charges to be able to do an arraignment today. If they're wanting to waive a probable cause determination, there are forms that we can prepare to do that. So that's up to, but I'm going to say there's going to be additional counts that go through as well, but I can present those to the defense. If he wants to waive the probable cause determination, we can do so. If not, it will be proceeding to the grand jury.
I think the important, well, I think it's 10 days. I know we're at March 31st, still some time there for that to be done, but Mr. Myers does want to invoke his speedy trial rights and wants the 150 to start as soon as possible.
Understood. And I think for purposes, again, of this hearing, the court only has to consider one charge. I think the state does have the ability to go forward on other charges. And it does sound like these may not be the only 2 charges that the state does intend to proceed on. So I'm sure Mr. Myers and Mr. Parvin, you obviously will continue to assert his rights going forward. Anything else that we need to do today?
No,
All right.
No, Your Honor.
Thank you all.
Well, well, congratulations, Lane. He's got his find out moment. I don't know. I don't know why people think that they can act a certain way. Well, I do know why. Again, I don't know why I ask these questions because I know the answers to them. But these guys just like again, they always think that public officials are less than human and that you're free to say and do whatever you want because they happen to be in a public position. So, all right.
Settled on the side of the road. No fuck, shithead. You're not kidding, are you? Because
what the hell is this?
He went to court in September trying to defend his mother, and John Carl Lanchowski took that away.
You got it.
Because he wears a black fucking robe. Stick
the
robe up your ass, John Carl Lanchowski.
You're mad?
You guys
He's
need
mad.
To be cursed.
Cursed?
I hope your dicks fall off. I hope your dicks fall off. And I hope that you get fucking cancer and die. You're worthless pieces of shit. I'm just wishing that happened.
Whoa, whoa, whoa. No.
My goodness. Anyway.
On me.
It's hey, cut the stream. That's it. We're done. All right. Hope you guys do a good. Hope you guys had a good time. I did. I will see y'all. I will see y'all probably not tomorrow, but I will see y'all Friday. I'll see y'all Friday for the championship match with Judge Simpson and Judge Oakley. Oh, I'm sorry, Jimbo. Thank you for the $5 super chat. Thanks, Jimbo. Check out my Discord, hit that like button on your way out, and I hope you guys have a good rest of your evening. All right, take care. Adios. Later.